What if I'm out of status, married to a US citizen, and I want to file an I-130 with an I-485 application? So you want to basically submit a one-step adjustment of status where you file the I-130, I-485, I-864, which is the affidavit of support, and optionally the work permit and advanced parole applications all at the same time. That's referred to as a one-step adjustment of status. Hey guys, there's a lot of misinformation out there about when filing an I-130 petition will result in deportation proceedings. So I've heard from a lot of people who've consulted with me recently that they're afraid to file an I-130 petition because they don't want to end up in deportation proceedings. And there's a lot of confusion about whether filing an I-130 by itself will result in deportation proceedings or whether filing an I-130 along with an adjustment of status, the I-485 application, carries the same risks. For anyone who hasn't seen my other video on this topic, USCIS changed or amended its policy manual, I think it was in the beginning of August, indicating that an I-130 petition is not an application for an immigration benefit. An I-130 petition is just a prerequisite. You need an approved I-130 petition to apply for permanent residence in the future. An I-130 petition is not an application for permanent residence, and I've seen a lot of people make this mistake. And that policy manual guidance basically says if you file an I-130 and you're otherwise deportable, you're likely to be placed into removal proceedings. The question a lot of people have been asking is, what if I'm out of status, married to a US citizen, and I want to file an I-130 with an I-485 application? So you want to basically submit a one-step adjustment of status where you file the I-130, I-485, I-864, which is the affidavit of support, and optionally the work permit and advanced parole applications all at the same time. That's referred to as a one-step adjustment of status. When you file a one-step adjustment of status, you will not be placed into deportation proceedings, at least currently, even if you are out of status. However, if your I-485, your adjustment of status application, gets denied and you are not otherwise lawfully present, you don't have some other sort of backup status that you're currently in, legal immigration status, then you will receive a notice to appear in immigration court. Conversely, if you file just a standalone I-130, you file just an I-130 for an immigrant family member, the beneficiary, and that beneficiary is in the US and out of status, they are likely to receive a notice to appear in immigration court, even if no decision has been made on that I-130 yet. We filed a couple I-130s earlier this year for immigrants who are out of status. The plan was to continue, once the I-130 gets approved, we're gonna file unlawful presence waivers and then get the client, send the client back to the consulate in their home country so that they can re-enter as permanent residents. And a lot of those I-130s are still pending, and the clients have already received notices to appear in immigration court. So now we have to switch up the strategy and defend them in removal proceedings. Now, luckily, most of them still have some options available, but it's not something we expected. What USCIS officers had privately been telling immigration lawyers beforehand was that once a final decision on the I-130, a standalone I-130 is made, if the immigrant is out of status, then the case will get referred to ICE, enforcement and removal operations to generate and issue a notice to appear in immigration court. But that's not actually what's happening. I-130 petitions that are pending are also getting notices to appear, but only when they are for immigrants who are out of status in the US and not attached to an I-485 application. So the key thing here is that you generally don't want to file an I-130 petition for someone who is out of status in the US, especially if they entered illegally, because right now under current Board of Immigration Appeals case law, that person might be subject to mandatory detention. In fact, they currently are. We're waiting for this to be challenged in higher federal courts. But currently, as of like today, in October 2025, if you entered the US without inspection and you're detained by ICE, you're probably going to be subject to mandatory detention where you're not able to be released on bond. Anyway, guys, this isn't to discourage people from filing adjustment of status applications. Actually, it's the contrary. I think most people who qualify for marriage-based adjustment of status probably should submit the application. Of course, that's a blanket statement. That's not legal advice. I would speak to an attorney who can hear the specific facts of your case to determine how much risk is involved if you apply for adjustment of status. Because remember, today, doing nothing also carries risk. So you need to weigh the costs of doing nothing versus the cost of applying and getting denied. So if you want to speak directly to an immigration lawyer to see what the chances of success are, what the risks are, if there are any other options, if waiting and allowing some time to pass might create more options or reduce the risk, then schedule a consultation directly with me, Puyan Darian. I'm an immigration lawyer. I practice immigration law nationwide. So anywhere in the United States, you can contact me, schedule a consultation, and I can either answer your questions, help you create a strategy, or represent you in your entire case from start to finish, depending on what your needs are. My goal during the consultation is to give you as much value, answer all your questions. I want you to leave the consultation feeling like you got a good value after that. So if you need any assistance, you can find the booking link for my consultation directly in the video description below, and I would love to speak to you guys. All right, guys, thanks for watching, and I'll see you next time for another video.